The federal transfer tax system basically consists of an integrated estate and gift tax system. What does that mean? Well, what that means is that on a federal level, an estate upon death is taxed at a rate of 45% for anything above the applicable exclusion, it's called. What that means is if the applicable exclusion is $5.43 million, which is what the current applicable exclusion is, an individual can die with $5.43 million in your estate and experience no federal estate tax. However, this is a cumulative exemption. And what that means is if during your life you have gifted 5.43 or any amount less than that, which is a taxable gift over and above the annual exclusion of $14,000 a year that we all hear about, then that amount is tracked during your life. And so, for instance, if you have gifted $2 million during your life, you will be able to pass another $3.43 million estate tax free at your death. Also, this tax is called an estate tax, which means it is assessed against the estate before the proceeds are distributed to your heirs. And this is versus an inheritance tax, and we'll talk about that later, which can be assessed on state levels. There is also an additional exemption for $5.43 million, which is called a generation skipping applicable exclusion. And what that means is you can gift, in addition to the 5.43 to anyone in your life, 5.43 to any generation which skips your children and goes to grandchildren or further removed generations. This $5.43 million is portable, and what that means is that for a legally married couple, which includes same-sex marriage couples, where it's recognized in that state, that basically the $5.43 million is doubled to $10.86 million for that couple. There are some requirements in order to avail yourself of that system. However, upon the first death, the surviving spouse must make sure to include that tax election on the estate tax return of the decedent.